Good afternoon, everyone. Welcome to this webinar on COVID-19 and the deprivations of liberty. As Rachel said, I am presenting together with Zoe Harper, and I think all I'm going to do is to tell you what we're going to cover in today's seminar first. Then Zoe will present on the domestic regulations that are relevant to our webinar today. And then I will discuss the practical implications and possible ways of challenging deprivations of liberty in the time of the pandemic. Now, the issues we're going to cover are in domestic law, are the domestic law as it relates to MCA and DoLS at the time of COVID-19. We're going to look at the government guidance relevant to MCA and DoLS. We're going to look briefly at relevant international law guidance, practical implications for those subject to DoLS, and challenges to DoLS during the pandemic. So those are broadly what we're going to look at. Many of you might have already seen, and I know that there have been a series of webinars in the last few weeks. I mean, I think we as practitioners are possibly overloading everyone with webinars, but just to be clear, what I'm looking at today in relation to DoLS is just deprivations of liberty themselves and how they're affected and how the decision making in relation to them might be affected, and not necessarily on some of the other things that have been raised in the DoLS guidance, which are like deputies and attorneys, and of course advanced decisions. That's going to be the subject possibly of another webinar. So for the moment, I'd like to introduce Zoe, who will be dealing with the domestic position and giving you a pointer towards the relevant guidance and direction. Thank you.
Thank you. So I will start with domestic law as it relates to the DoLS regime. The guidance that's been issued so far has explained that during the pandemic, the principles of the Mental Capacity Act and the safeguards of DoLS still apply. And that's absolutely correct, that in fact, the Mental Capacity Act 2005 is in force in its entirety. Although the Coronavirus Act 2000 made changes to a number of other areas relating to care and COVID-19, the Mental Capacity Act 2005 and the Deprivation of Liberty safeguards remains entirely unchanged. Rachel, if you could switch to the next slide, thank you. What has changed, however, is the context around that legislation, and that new context creates new challenges that are likely to affect the practical care and treatment arrangements for persons lacking capacity. Guidance has been issued that deals with some, although we will see not all of these, but areas in legislation and practice that are likely to affect care and treatment have been identified as the provision of treatment to persons lacking capacity where COVID-19 is suspected or has been contracted, and what needs to be in place to ensure that they're able to receive treatment. Support for persons lacking capacity in protecting themselves from infection and self-isolating. The separate regulations dealing with movement and gatherings under the health protection coronavirus restrictions. For example, speaking here about the legislation that requires people to stay at home and not leave their home unless there's a reasonable excuse, and that may present challenges for people with perhaps autism or learning difficulties, learning disabilities, that may make it more difficult to support them in complying with that guidance. separate regulations have been issued in order to put in place emergency public health powers, where if a person is suspected of having or has COVID-19, that there are emergency health powers that enable them to be, for example, quarantined or undergo screening and testing. Other broader issues that may affect the arrangements for care and treatment for persons lacking capacity would involve workforce capacity and, for example, staff absences and other vulnerabilities in the provision of care caused by COVID-19. So we're already seeing, for example, that care in the community may be affected by lower numbers of staff being available, or the sustainability of care provided to people in community settings being perhaps less straightforward, with the risk of staff becoming unwell and being absent from work or through self-isolation. There are also increased pressures on health and social care resources all round in terms of prioritising the focus of local authorities, as well as the general pressures caused through impacts on capacity and absences. As well, and we'll speak later about the evidence of increased risks of COVID-19 infection in congregate care settings. So, for example, residential care settings where there are a number of people supported together. So, next slide. So in that context, a number of pieces of guidance have been issued by the Department for Health and Social Care, as well as the NHS and other bodies, that are aimed at providing guidance to people in the context of those challenges, and particularly with this client group. That there has been perhaps guidance overload, and I've sort of picked a few key pieces of guidance here, the most relevant of which are the first two on that list: the emergency guidance issued on the 9th of April, the mental capacity and deprivation of liberty safeguards during the coronavirus pandemic, and the action plan for adult social care. And Ulele is going to speak in much more detail about the changes that are created by those two pieces of legislation, of guidance, sorry. There has been, just go back to the previous slide. There has been guidance issued around the admission of care of residents during the COVID-19 crisis in a care home previously, but there is a note in that guidance that that's being reviewed, because many of the points identified in that guidance are discussed in the updated action plan for adult social care published on the 15th of April. And there is also an ethical framework for adult social care, which is aimed at providing guidance around the prioritisation of services and care in contexts where there are increased resource pressures. And further on increased resource pressures, the COVID-19 hospital discharge service requirements is relevant, because it discusses the need for prompt discharge from hospitals in order to free up NHS space, and that identifies that the need for promptness, even though there may not be the ideal setting to which a person may be discharged to in terms of the practicalities under the Mental Care Act 2005, but much of those practical points are dealt with in the action plan for adult social care, which was issued in the context of some of the very real concerns raised about discharges of persons who may still be infected with COVID-19 and the risks of discharging them to care homes. And that action plan deals with many of those concerns. In terms of the guidance, the first guidance on the list, the emergency guidance on the DoLS and the Mental Capacity Act, this is very much aimed at a pragmatic response to the context. It's clear that the Mental Capacity Act 2005 still applies as the guidance states, but at paragraph 21 of that guidance, it identifies that there are pressures, and as long as practitioners demonstrate that they have followed the principles of the Mental Capacity Act, then in providing appropriate care and treatment, then it will be understood that people have done as much as they reasonably can in order to prevent human rights violations. But it must be remembered that the Mental Capacity Act 2005 applies in full, and Section 5 and Section 6 only provide defences where there is sufficient compliance. So the message very much is that there are pragmatic responses, but extremely important to be compliant with the Mental Capacity Act and a code of practice and that guidance. But Ulele is going to speak to the changes in particular in relation to the first two pieces of guidance there, which in the context of guidance overload gives perhaps the greatest information about changes to practice.
Thank you, Zoe. Thank you, Rachel, for changing the slides. Right, as Zoe has said, the key domestic guidance, that certainly the guidance that I'll be looking at today, because the action plan and indeed other social care provisions of changes made to the Care Act have been dealt with in previous webinars. So in essence, I will be looking at what's going to happen to DoLS, what's going to happen to DoLS in care homes and hospitals, and what's going to happen to DoLS in the community, and what is there to be done, what should we be doing on behalf of incapacitated persons, or what advice should we be giving to local authorities and supervisory bodies and and CCGs where appropriate. Rach, can you change to the next slide, please? Right. So I just want to run through something that people might be familiar with by now, but it's worth repeating because it's so important in how we manage practice and representation of P during this period. The first point to note is that life-saving treatment provided in care homes as well as hospital will not give rise to deprivations of liberty. Many of you will be familiar with the case of Ferreira, where the court held that life-saving treatment in hospital did not give rise to a deprivation of liberty. In essence, what the new DoLS guidance does is to say that treatment of a life-sustaining kind, which is given whether in a care home or hospital, will not be covered by the deprivation of liberty safeguards and will not give rise to a deprivation of liberty. So it's extended Ferreira to some extent to outside of the hospital setting. So that's point one. The usual Cheshire West test is to be applied to changes to an individual's care and treatment arrangements, and where there is found to be a deprivation of liberty, decision makers must follow their usual DoLS procedures. Now, what this means is this: if there are, for example, measures taken in relation to persons who are either not DoL'd or DoL'd, but the changes are significant such that another or a review of the DoLS is necessary to include the changes, then that must be done according to the usual procedure. So no changes there. However, there is a truncated urgent authorization form that could be used during this period. And this just means that it's easier to seek an urgent authorization in these circumstances. That's the point. And there is, with the time over which the urgent authorization can take effect isn't changed. It's the 7-day extension still exists, but it is anticipated that that extension might be granted more readily in these circumstances. So if treatment is being provided in another setting, for example, home or supported living, authorization from the Court of Protection will need to be sought. So again, there is no change to the philosophy that we are all aware of, which is if at present, and this will change when we get the liberty protection safeguards, but if at present you are depriving someone of their liberty in the context of a care home or a hospital, then the relevant procedure is the DoLS procedure, is deprivation of liberty safeguards procedure. If it's home or supported living, then you're looking at applying for authorization from the Court of Protection. And
Ulele, you're muted.
Hi, I'm just checking to see what, I'm sorry, I just was informed by Rachel that I was muted during that period. So I should just recap what I was saying, which is in the first instance, life-saving treatment provided in care homes as well as hospital will not give rise to a deprivation of liberty. The change there is that FERERA is extended to treatment in care homes during the pandemic, and DoLS will not apply to this cohort of persons. So if you're being treated for life, in order to save your life in a care home or a hospital, that will not be a deprivation of liberty, and there will be no requirement to use the DoLS safeguard procedure. Where there is a DoL that is outside of the FERERA type context I've identified, then the decision makers will follow the usual DoLS procedures, that is urgent and standard authorizations reliant upon qualifying assessments. There is a truncated urgent authorization form which should be used during this period, and that form is designed to allow, I anticipate, applications for urgent authorization to be made more quickly and more easily. If treatment is being provided in another setting, home or supported living, then the usual procedure also applies, which is that you go to the Court of Protection and ask for authorization there. I understand that just today, there has been a new COP DoL11 provided by the Senior Judge Hilda. I myself have not seen the text of the COP DoL11, but I know that one has been provided, so practitioners should be looking out for that. Next slide, please, Rachel. Now, the other crucial changes that are to be noted is that DoLS assessors are not, the default position, pretty much like the default position in relation to hearings, is that there should be no face-to-face visits unless essential. And previous assessments can be relied upon to inform the assessment, the current assessments. And it should be noted that assessments older than 12 months can be relied upon to inform assessments, but are not to be treated as equivalent assessments. So the same rule applies in relation to equivalent assessments. There's no change there. Equivalent assessments are assessments made in the last 12 months, and they can be used. You don't need to do another assessment if you have an equivalent assessment. But in relation to assessments made for a period of greater than 12 months, they can be relied upon, but it's not the same as an equivalent assessment. Now, where restrictive measures are used only to prevent infection or harm to others, public health powers rather than MCA powers ought to be used. And at paragraph 30 of the guidance, it refers specifically to public health officials who have been granted powers to deal with restrictive measures which sit outside of the MCA itself or the DoLS regime. And just for example, by way of example, the public health powers are the kind of powers we've seen in the Act itself, which is the powers that Zoe alluded to earlier, which is that not leaving home unless there's a reasonable excuse, and reasonable excuse amounting to exercise, the getting of groceries, or seeking of essential medical treatment, etc. And that the requirement to stay at home to avoid certain practices can be enforced via the use of the public health powers. So it's interesting there that what the guidance is clear about is that there are no circumstances in which restrictive measures not aimed at protecting the person themselves can be used or applied via the MCA. And that perhaps endorses the recent approach of the courts to this issue. Next slide, please, Rich. Now, there are a few important points that I think we should note in relation to the DoLS guidance, which is and this I suspect can't be stressed enough, because it's important for those practitioners who are representing P and family members potentially at odds with local authorities, etc. What's important is that it applies only during the pandemic or until withdrawn by the Department for Health and Social Care. It's not guidance that will be applicable thereafter. It creates no new law, and the principle of least restrictions still applies to the decisions made by reference to it. And at 2 or 3 points in the guidance, it refers to the need to apply the principle of least restriction. Decisions should be made in accordance with best interest principles, save where purely made for the prevention of harm or risk of infection to others. And therefore, in those circumstances, as I mentioned earlier, public health powers are more apposite. Now, interestingly, whilst the principle of least restriction is reinforced at various points in the guidance, there is no guidance directed at considering release from detention as a public health measure. And when I say that, I mean that there may be circumstances in which compliance with, for example, the Human Rights Act obligations might require consideration of release from an authorization of a deprivation of liberty. But there is nothing in the guidance which suggests that that should be considered. So it's not something that's being encouraged by the guidance. Next slide, please, Rachel. Now, what international law might be relevant to this context? And the relevant international law, as I see it, the key, and I should say key because there is more. The key is Articles 2, 3, 5, and 8 of the European Convention on Human Rights, which I'm sure most people listening to this webinar are familiar with. The right to life, protection against inhuman or degrading treatment or punishment, liberty, and of course, respect for private and family life. Now, the CRPD is also relevant. And as you know, the CRPD is used as a tool for interpretation domestically rather than being directly enforceable. But the relevant articles are Article 9, accessibility duty, 10, right to life, 11, situations of risk and humanitarian emergency, Article 15, freedom from torture, inhuman and degrading treatment, 16, freedom from exploitation, violence and abuse, and 25, the right to health. So those largely mirror the relevant convention articles as we know them. So those are things that you might want to have in your armory when you're thinking about challenging deprivations of liberty that occur in the context of this new guidance. Now, just turning to the next slide, please, Rachel. The other kinds of interesting international information, so to speak, or statements are some of the other kinds are mentioned here. And I want to thank Oliver Lewis for having, as it were, prefigured this in an earlier webinar he did in several seminars he's done on or several papers rather, Passle's and others he's done on this issue. Now, there is a bulletin called the Coronavirus Pandemic in the EU, Fundamental Rights Implications, which has been produced by the EU Agency for Fundamental Rights. That's quite helpful to look at. And in particular, it sets out what fundamental rights might be affected in the course of the pandemic and what states have been doing to ameliorate any interference with those rights and what states might do in order to improve public health in the context of this emergency. The WHO has issued infection prevention and control guidance for long-term care facilities in the context of COVID-19. And it's also issued further guidance on disability considerations during the COVID-19 outbreak. And indeed, Michelle Bachelet, the Council of Europe, has issued a statement referred to as urgent action needed to prevent COVID-19 rampaging through places of detention. And that, in a sense, is relevant to what we're looking at today and how we as practitioners manage the deprivation of liberty context during the pandemic. Next slide, please, Rachel. Now, I've titled this series of slides Better Out Than In, because I'm asking the question, I'm posing the question as to whether or not there may be circumstances not alluded to in the domestic guidance where it is actually better for the persons concerned to be out of the care homes or residential facilities and indeed prisons than in. And it's useful to look at the statements that I referred to made by Michelle Bachelet. And one of the things she has said is that COVID-19 has begun to strike prisons, jails, and immigration detention centres, as well as residential care homes and psychiatric hospitals, and risks rampaging through such institutions extremely vulnerable populations. And one of the things that is relevant here is, again, something that Oliver Lewis alluded to in his presentation, his last webinar presentation, was that, of course, in congregated facilities, the spread of infection is high. It's not always appropriate, it's not always easy to ensure adequate physical and social distancing, particularly where you've got persons who might lack decision-making capacity and might be unable to follow the kinds of steer or direction that many of us are given. I mean, let's face it, that in certain circumstances, many of us who have decision-making capacity have not been following government guidance on social distancing and physical distancing. So, and then there is also the lack of relevant PPE. And so there are all sorts of risks which are attendant upon those settings themselves. So Michelle Bachelet urged authorities to release those particularly vulnerable to COVID-19. And we know that the cohort within care homes, and certainly the demographic that we're looking at, will have a series of comorbidities, including all sorts of illnesses that are definitely going to make them particularly vulnerable in the context of COVID-19. Particularly in the elderly population, you're looking at diabetes, hypertension, and all sorts of other high risk or illnesses which make them high risk and which would put them in the category of persons who might receive shielding letters in the context if they weren't in hospitals or care homes. So one of the other things Michelle Bachelet stresses is that measures taken amid a health crisis should not undermine the fundamental rights of the detained people. And when we think about those fundamental rights, we're thinking about the rights I identified a few slides earlier, which is the Article 2, 3, 5, and 8 rights, and the correlative rights under the CRPD. Next slide, please, Rachel. So again, continuing with the theme of better out than in, or posing the question as to whether it's better out, whether P's are better out than in certain contexts. It's useful to look at what's been said in the prison context. And I say so because there's been a lot of focus, certainly in the domestic media, about the prison context. And indeed, Richard Garside, the director of the Center for Crime and Justice Studies, has said, if you set out to create an institution with the express intent of concentrating and transmitting COVID-19, it would probably look much like a prison. Similarly, a leading epidemiologist, Richard Coker, has described prisons as epidemiological pumps. So in a sense, these are petri dishes for the transmission of COVID-19. So when you look at institutional, if this is what is being said about institutional settings such as prisons, some of that rationale, some of that analysis, it seems to me, must also apply, some of it, to care homes and hospitals in which those persons with whom we are concerned might be accommodated. At present, it is said that the residential and nursing home deaths due to COVID represent some 5,000 of the 18,000 deaths to date. So, next slide, please, Rachel. The question that begs is whether or not prisons are the same as residential facilities. And as I said, there are many ways in which they are, in the sense that they're institutions of care where there are lots of people present. There's lots of risk. there's a high risk of infection because of the congregated setting. But beyond that, what are the distinctions, and how ought we to, as it were, draw analogies if in cases of potential challenge, or draw distinctions? Now, care and nursing homes are served by health and social care professionals and are intended to be therapeutic institutions rather than facilities for containment, which is what prisons are. I mean, some prison lawyers, or some people, certainly the prison service would say that prisons are for rehabilitation as well as containment. But in terms of their settings often designed to avoid risk until that risk has been ameliorated. So in one way, the care and nursing home setting is likely to be more hygienic, possibly, and directed towards well-being, and therefore more therapeutic. And so you might anticipate that the staff in question, and indeed the personnel in question, might be better able to comply with guidance on protection and social distancing, etc. Individuals in care homes are sometimes likely to face greater risks of infection in the community than in care or nursing homes. And this is a very relevant point, because it seems to me that this is where any potential challenge to the use of DoLS during the pandemic and restrictions imposed whilst on a DoL during the pandemic, this is the crucial point or distinction. And it would be crucial, for example, in any challenge based on the risk of infection while subject to a DoL in a care home, would have to be able, it seems to me, to adduce evidence that there is a greater risk of infection in rather than out. Now, on the outside, people don't necessarily follow social distancing protocols. They may not use masks where appropriate, and indeed persons who lack capacity may find it more difficult to abide by those regulations and may not even understand them, and in certain circumstances might find themselves in a position where they fall foul of the regulatory framework which has been enforced by the Coronavirus Act. So one has to look really closely at whether there's a greater risk of infection inside or outside. In light of those restrictions, there will be cases in which individuals are or can be made to be safer in residential care than in the community. Now, one of the crucial issues, it seems to me, that goes towards this exercise of determining which of the two is the safer environment is really what the extent to which the environment is supplied with PPE and other protective measures. Now, if we are to heed what is being said by practitioners within the NHS, I mean, even in hospital settings, in general hospital settings, and coronavirus hospital settings, we are hearing that there is insufficient PPE. But it's likely to be insufficient PPE also, it seems to me, in care homes and in residential care homes, if that is true of the general hospital settings in which coronavirus patients are being treated. Many, though not all, individuals in residential care are there because they are unable to live safely in the community. So again, the question is, what is the risk? What is the relative risk of the two settings? Next slide, please, Rachel. Now, if we are to look at the question of discharge during the coronavirus or pandemic, what it seems to me we have to look at is, particularly if we're looking, I should say, if we're looking at discharge because of risk due to coronavirus in congregated settings, it seems to me that these are some of the relevant issues. Firstly, the Coronavirus Act specifically requires local authorities to meet care and support needs so as to avoid a breach of convention rights. Now, those of you who attended Mary Rachel's webinar on the care and support guidance and the changes there under the CARE Act, you will have recalled that she talked about easements, not the kind of easements that those of us who have a vague memory of property law believe easements are, but the easements of, as in the disapplication of certain duties under the CARE Act. And one of the backstop position in relation to the Coronavirus Act is that they're relieved, social care, local authorities are relieved of those duties, save insofar as they need to meet care and support needs to avoid a breach of convention rights. So the ultimate, if you like, the ultimate test is whether or not convention rights have been or might be breached. And I mean, this will come as something of a interesting development for those who practice in community care law, since of course in several ways the courts have said on a number of occasions that the provisions of the Care Act and its predecessor are sufficient to deal with convention rights in most circumstances. So convention rights are not looked at in that great detail in your run-of-the-mill case. But now it seems to me that the breach of EHRC rights might become the touchstone of whether or not care and support needs are going to be met during the crisis. This may lead, and I'll come to why this is relevant in the MCA context, but this may lead to renewed focus on positive obligations under Articles 2, 3, and 8, because once the convention becomes relevant, then the issue of what local authorities ought to do by way of positive obligation gets placed in sharp relief. Next slide, please, Rachel. So my general sense of this is that, and I'm sure you all might be familiar with a recent case that was determined by the Vice President of the Court of Protection, Mr. Justice Hayden of BP, and we saw that he upheld contact restrictions in a care home setting in relation to a profoundly deaf person, and these contact restrictions prevented visits except by way of waving from a window and using the communication board. So it would be my view that one has to be very careful when mounting arguments on the basis that the risk of infection is higher in care homes and hospitals than it would be in the community. And of course, this requires an individualized analysis, as is required by the guidance and indeed everything we know about MCA and DoLS. So it would be my view that where you have a borderline case, or where you have a case where discharge or the termination of a standard authorization or a deprivation of liberty is marginal or likely, or it's potentially likely that you have a good argument about that, it may be useful to bring attention to a measurable or appreciable risk of infection in the case of a vulnerable individual. And you will also need, it seems to me, to point to a safe community placement with the real possibility of adequate care. Now, the difficulty with this, as I see it, is the adequacy in terms of adequacy of care, is the concern I have, certainly, that care in the community will be as affected by the resources implications that Zoe alluded to earlier as would care in care home settings. And in some commentary on an article that Oliver again penned in relation to this, I noticed that a lot of social care professionals were suggesting that carers, for example, home carers, are not being tested for COVID-19. At least there is some undertaking to test those in hospital and care home settings, and that it is more difficult to enforce social distancing protocols at home in certain circumstances. And of course also that most social care professionals are applying the principle of least restriction, and therefore are not housing persons in care homes or subjecting them to deprivations of liberty, except where there is no other mechanism for ensuring that their best interests are protected. So it seems to me that an argument for discharge based on the risk of infection in coronavirus terms requires, it seems to me, two things: both statistical evidence of the risk and also perhaps evidence of risk in relation to the particular vulnerable individual, and evidence of and clear evidence where applicable of the vulnerability of the particular individual in question. Next slide, please, Rachel. It seems to me that in appropriate cases, and appropriate cases in my view would be the kinds of cases I just identified, it could be argued that the state has a positive obligation to preserve life through health, and this can be argued in reliance on Articles 2 and 5 of the ECHR with the assistance from the CRPD. And one of the things that could be argued also about why a deprivation of liberty in a care home setting might not be appropriate is that an absence of contact with intimate family members would not be justified having regard to the detrimental impact of the risk of infection and the mental health deterioration in residential care in the absence of that contact. So, it seems to me that one has to look at the whole gamut of convention rights for these arguments, and it's useful, those of us who practice in the Court of Protection, we need to reskill ourselves in convention law, because it seems to me that the convention is going to become quite relevant to these sorts of arguments in any event. Now, facilities in which the risk of infection are high and preventative measures inadequate may make a continued deprivation of liberty unlawful. And the authority for that is a case called Hiller in Austria, in which the court said that if the environment is not of therapeutic benefit or places the person at risk, and I paraphrase, then the deprivation of liberty may not be lawful. Now, this is a sort of, it's a sort of slight deviation from the kind of Ashingdane principle that many of us will be familiar with, which is that it's not, conditions of detention do not affect detention. It's just that it's just whether or not one is detained. But in this case, it's saying that if the environment is not appropriate for the aim intended, then the deprivation of liberty may become unlawful. So that would be another string to the bow in a case in which you were seeking to argue that the risk of infection militated in favor of a discharge or a termination of a DoLS authorization. I think, if I'm right, that is the last slide. Rachel, can you confirm for me? Yes, it is. Right, so thank you very much for attending, and I hope that was of some use to you, that quick canter through the new DoLS guidance and the implications for practice. Thank you very much. Those of you who have questions, I will look at the question and answer. I see that there is one, and I think it's a comment from us really rather than a question, and it is that public health officials on the Schedule 21 of the Act have no powers on the lockdown regulations in relation to stay-at-home and gatherings. Their powers relate, quite correct, to screening and assessment of people suspected of being infected or actually infected, and it's worthy of noting that. And I'm grateful to Zoe for sharing that. I just wonder if anyone else has any more questions in relation to this, or anything presented today. Zoe.
There was one other question that I've answered in text on the chat, but we'll answer here as well, which was, what is the GDPR position in respect of informing other persons, for example, in a hospital or care home, the manager informing others about P's suspected diagnosed COVID-19 to prevent spread of the virus, particularly if they've moved from one setting to another. I've put a link in the chat to the Information Commissioner's Office, which has actually very helpful and accessible guidance on data protection generally in the context of the public health emergency. And it actually deals specifically with this scenario in the sort of FAQs as a manager of a care home, can I tell a resident or their family if another has contracted COVID-19? And they explain that ideally, you don't disclose the identity of the individual unless it's absolutely necessary under the specific circumstances, and this applies because of the duty to ensure the health and safety of your residents, and data protection doesn't prevent from doing that. So But the other guidance more generally from the ICO is it also explains that, you know, as a data commissioner, that they take a reasonable and pragmatic approach, and taking into account the compelling public interest, and, you know, one of the key messages is proportionality. But it's also a useful reminder about the importance of data protection generally, particularly when we're thinking about creative approaches to contact and you know, following the guidance, the decision in BP, and thinking, for example, of where residential settings and care homes might use Facebook or other types of communication that always also bear in mind data protection implications, and that might involve limiting the use of certain types of communication or specific settings that ensure that people's personal data about them being in a care home or a residential setting is protected.
Thank you for that, Zoe. It seems that we have, I don't think there are any other questions as far as I'm aware. If anyone else has any questions, the time is now. Otherwise, I would suggest you sit in splendid isolation in the sun. Are there, I'll hang on a few seconds to see if there are any other questions. It doesn't look as though anything's coming. So in the event that there are no questions, I'd just like to say thank you everyone for attending. And this I believe is our 4th seminar in this series, webinar. And I invite you to keep your eye out for the next seminar. And there are a few more in this series, and we hope that this is a continued way of information sharing and indeed discussion between ourselves and solicitors and other practitioners. Thank you very much.